Very recently in the High Court, what I've seen that there have been number of litigations pertaining to a banking phenomena. Now, this particular phenomena comes out of a circulation promulgated by Reserve Bank of India, and this circulation primarily addresses to the fraudulent characters of financial transactions, primarily that happens within the banking sectors. And this particular instant is called classification and reporting of accounts, financial or the banking accounts, by the borrowers, classifying them as fraud. And uh, if you have encountered similar kind of, if you are a, what would I say, if you are an advocate practicing, then you probably know. Otherwise, you can just go to Google and type master circulation on fraud classification and reporting. You do have subsequent circulars as well, but I'm not into the main content, but rather the essence of this circular, which is marking an account or classifying an account as fraudulent account or fraud account. Now, this to understand, first you need to go to the introduction section. Once you go through, you have a better understanding what this section is and what is the main objective. So it says that incidents of frauds, dacoits, robberies, etc., in the bank are a matter of concern, while the primary responsibility for preventing frauds lies with banks and themselves. The RBI has been advising banks from time to time from the major fraud prone areas and safeguarding necessity such and such and such. So, what it is doing is it's mainly addressing the different illegal or irregular activities can also be termed as fraudulent activities that are prevalent in banking sectors, like not paying your loan, or fraudulently getting loan, different sort of activities pertaining to negotiating instruments. So any kind of frauds or irregularities that are out there pertaining to banking sector. And what this particular does, let's say that you take a loan for xyz purpose, and somehow you fail to pay the loan. uh, your account can be termed as a fraud account. Now if that happens, under 1.3, what it asks is that the reporting of fraud and consequent delay in alerting other banks. So, anyway, it's written in such a manner that this particular act is welfare. But if you understand what they are actually doing, it's sort of a colorable, circulation. Basically, it advocates prosecution by banking sector. So now, in many ways, banks do not even need to go to any judicial forum. They themselves can prosecute someone as fraud. And when they do so, they are going to report the same to their other associates or other banking agencies, informing about you and your account as a fraud account. Now, the one of the ways it does so by invoking Indian Penal Code. It says under Section 2 classification, and the way it does, it takes the ingredients from Indian Penal Code, and there are many ingredients such as misappropriation or criminal breach of trust, negligence, or cash out. So it takes certain ingredients from IPC and then using it in the commercial context. Now, the first question that I have with respect to this: can economic offenses be equated with criminal offenses? Because IPC is strictly a criminal, or what would you say? It deals with core criminal activities. Criminal offenses and the economic offenses or political offenses, these are all different offenses, and they are when they are assessed or evaluated, there are individual metrics which are applied to evaluate the same. Now, in this case, what the RBI is doing, taking ingredients from the criminal offenses and using it to prosecute individuals for anything that might happen that might lead to prosecution under this fraudulent account. Now, if this logic, if one thinks that this logic is a valid logic, then I have a question, that is, can a promoter be tried under IPC 307 for illegal building, or let's say unauthorized building, or any building that eventually uh, meets with certain mishaps? Like in across the states, there have been number of cases, building falling down, bridges falling down, right? Now, for 307, attempt to murder, it says that if you know the act, that your act is likely to cause the death, and if you have that knowledge and then you act upon it, then it can be construed as attempt to murder. Now, if you take the word knowledge, we all have this common understanding that when a railway bridge, or let's say any bridge, or a building is constructed, or any construction for that matters, there are certain rules and regulations which are based on certain knowledge, that a bridge needs to be made in this manner, certain material standards need to be met, or eventually they meet with catastrophe. So we all have that knowledge. Now, a construction agency or maybe a promoter, for financial gain, which happens all the time, would cut corner to gain additional financial benefits out of it. And if that building falls, or the bridge falls, people die, should we prosecute them under 307? I do not know in the in whole Indian judiciary system if that has ever happened. And then the second similar analogy can be taken. Can financial organization be tried under IPC 306, which is for abetment of suicide? Now, there are many cases where financial institutions or recovery agencies have been caught for influencing, or resorting into coercive actions for recovering their monies and dues. And there have been cases where people have committed suicide. Now, do we prosecute them under 306? That will be the question for thinkers, I would say. The second part of the question of this phenomena is: can financial organization, uh, sorry, that's another case, operate as a judicial organization within the context of power to convict? The power to convict is specifically a power through the Constitution. It has been given to the judiciary or judiciary institutions, whether it is quasi judiciary or judiciary institutions, this lie. Now, financial institution, all of a sudden, they have decided for their own benefit or benefit of their brothers and sisters. By the way, I never said that why I'm whom I'm calling the devils. It's certainly the banks and the banking institutions. Now, in this particular video, I'm not going to justify why I'm calling banks as devils organization or devils. In case if I get any lawsuit for defamation or anything uh, like that, there I might make a separate video to address my position, why I term them as devil's organization. But for the time being, let's just take it as an axiom or universal truth that banking agencies or financial agencies are basically a devil's organization. Now, the question that can financial organization operate as judicial organization within the context of prosecution? Because this is a clear case of prosecuting an individual as fraud or his or her account, but eventually it's the person actually who will be the victim and probably will run from one pillar to another pillar to get things right. This process of or mechanism of conviction is purely a judiciary, uh, under the purview of judiciary mechanism. Now today, if financial institutions can do so, tomorrow some other organizations, they might come, they might also create something like this. And maybe the labor organization or private employees, they can create a portal where they would start marking their employees at maybe dishonest or whatever that suits probably that circumstances. They can also start prosecuting them. And if that's the case, then I have the last question, which is, why do we need judiciary? Even maybe uh, after a while, when the technology advances to certain degree, uh, the police authority may not need to be go through all these elaborate uh, judicial, you know, formalities that are there to prosecute. They can easily do so. So this precedent where a banking institution can prosecute an individual for whatever the reason, uh, somewhat it seems goes against I mean, the constitution of this nation, or for constitution of any nation for that matter. So I think uh, now again, as I said, there have been this circulation is from 2014. There have been additional circulations as well, but the overall the principle remains the same. It's the same identifying, or if they identify certain accounts which do not meet their standards or requirement, they can term them as or mark them as a fraudulent account, and then and once they mark it, they will report the same to other banking agencies. And when that happens, you may not be able to avail any other financial uh, services from those respective fellow banking agencies. So it's a very straightforward prosecution under financial laws. But anyway, whether this is justified or not should be looked within the context of the criminal offenses and within the context of economic offenses, and then the power to convict an individual. I would highly recommend, if you have some thoughts and opinion, do share those in the comments. Thank you.